Welcome, everyone, and thank you for attending. Questions can be asked using the Q&A pane in your WebEx event control panel. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. I will now turn the presentation over to Henry. You may begin.
Thank you, Kelly. Good afternoon, although it's, I think, exactly noon, so it's not really afternoon. But good afternoon, SHRMLI. This is Henry Shapiro. It is Friday, thankfully, August 28th, 2020, in a year that feels like it's been the length of probably the 5 preceding years. We are slowly drudging on and getting to the end of what has been a very difficult year for people, for families, for employers, employees, and the like. So what are we going to talk about today? Well, I would be lying if I didn't say that the most asked question or series of questions that I've received in the last, 3 or so weeks has been relating to school. What do we have to do for parents? What can we do? Can we tell them no? Do we have to tell them yes? What are we supposed to do about staffing shortages? On and on and on. And unfortunately, I don't always have the answers, although I like to pretend that I do. I don't always have the answers because a lot of these are questions that can't be answered because we just don't know yet. Every so often, we get a little glimmer of hope from whether it be the federal government or the state government that interprets something, sheds some light on current laws that we can then use as attorneys to figure out how employers can apply the law in their workplace. So we all know these dates. For those of you that have children, this impacts you. For those of you that have employees that have children, this impacts you. For those of you that were once children, which I think is everybody, this would have impacted you. So everybody should try to pay attention. This is a statewide thing. This is not city-specific or Suffolk-specific or Nassau-specific. This is statewide. Mostly we're going to actually talk about countrywide. And we will get into what employers should be probably on the lookout for. If you're not on the lookout for it already, definitely within the next week or two as school starts to go back. Obviously, we have a later Labor Day this year. I'm not going to sit here and opine on specific school districts because I have no idea what certain school districts are doing. But we all know that there's obviously different interpretations from schools as to what they think is best for the students, what they think works, what doesn't work, what's best for the teachers. So through all that, we get these laws, these rules, and then we try to figure out how we move forward. So as fall approaches, while parents of school-age children have decisions to make, employers with employees who are parents of children, school-age children, have decisions to make. So I kind of wanted to cover a little bit of everything. Obviously, I can't take questions on this, but I'm going to try to get to as much as I can. And then if questions pop up, what I can't do is opine on every specific situation, every unique hypothetical. As those come up, you speak with your counsel. If your counsel is Jackson Lewis, is me, give me a call, shoot me an email. Let's work through it together. We're not always going to know the right answer, but what we always want to do is make sure whatever we do is something that we're able to do consistently across the board. You're not going to get in the habit of making carve-outs for specific employees unless you're going to do it for every employee that's similarly situated. So what are some of the things to think about? What's my child's school district doing? Are they doing a remote/distance learning where everybody is going to be at home using their iPads and computers and no one's actually going to be in school? Is it going to be hybrid? Is it going to be a combination of in-person and distance/remote learning? Or is it going to be straight in-person? And I've seen so far from schools a combination of all of them. I've seen some that say they want certain grades to be all in person, and the higher aged or the higher grade children, so once you start to get to the middle and high school years, they're more okay with them doing a distance learning. I think the thought process is, and I am not an educator, I think the thought process is that the younger children, K through 4 or 5, whatever grade you go, or at least K through 2 even, that those children do better learning-wise with in-person learning. I'm not going to get into anything about the risk for children with COVID. It's not what this is about. This is not an opinion piece. It's not a political piece. It is strictly about things that you need to consider as an employer for your employees who have school-age children. So, what is my employer offering for my job? So, is the employee in a position that is caters to telework and remote work? Is it a position where they work on a factory line and they have to be there? You can't do it from a remote location. What benefits, if any, are available to me if I cannot work due to my child's schooling? What if I can't even telework? What if I have the ability, let's say, to telework? All I need is a computer and a cell phone, like yours truly, and I could telework. But what if I actually can't telework because my child requires care? My 7-year-old will destroy my house and possibly set things on fire if I don't sit here and parent my child. So I can't just, even though they're home, supposed to be in school, I can't just let them run amok. I need to make sure that I am giving them my close to undivided attention. I cannot dedicate myself to an 8-hour workday. That's somebody who might have the ability, or the capability, I should say, to telework, but can't actually do it based on their parental and child situation. Is it something forever? What happens next year? What if something changes in the next 4 months? It's the end of August. We still have, obviously, September, October, November, December. What if something comes up then and the state says, everybody go to school, or everybody out of school? What if there's outbreaks? I mean, we started to see that at some colleges. I think UNC had an issue. I've seen some issues pop up. I have colleagues who have family members that go to University of Michigan. I've seen things pop up there. There's parties, there's clusters, there's outbreaks. So I don't know what the future holds. I think it's worse, obviously, at colleges just due to the more carte blanche ability of college-age children, or adults, I guess, there's the adolescents, to do as they wish when it comes to roaming campus and going to parties. It's a little different for K through 12, but the more we see outbreaks, I think the more likely we're going to see the reins get pulled back and people less likely to, start sending people out into the world and sending their kids out into the world. So what's the main law that really matters for all of this? Is the Families First Coronavirus Response Act, FFCRA. I'm sure you've all heard it. I'm sure you're all sick of it. It's fine. You're not alone. We can fight that fight together as far as being sick of it. To be very clear, this applies to employers that have less than 500 employees. If you are on this webinar and you have more than 500 employees, although I do not want to lose you and do not want to hear you hang up, this is probably not something that is going to matter very much for you. You might have your own policies, and we're going to talk about generally what's good for employers to do when it comes to maneuvering the landmines of school age of employees of school age children. But just, full disclaimer, the FFCRA applies to employers with less than 500 employees. So it doesn't apply to, if you have 501 or more employees, it does not apply to you. So what was this? It's a law to give, or again, we'll just do a quick recap, a law to give emergency paid sick leave and emergency family medical leave. Who's eligible for it? It gives leave and paid benefits for employees for the emergency paid sick leave immediately upon hire. You hire them next day, they have a qualifying reason. They're subject to their own order of quarantine. They're caring for an individual that's subject to an order of quarantine. They were told by a doctor to quarantine. They are experiencing symptoms of COVID-19, and they're seeking a medical diagnosis. On day 1, day 2 of employment, they get emergency paid sick leave, whether it's they either get 80 hours if they're a full-timer, or they get basically a prorated version if they're a part-timer. The emergency family and medical leave, a little bit different than the traditional FMLA we all know and love, which requires 12 months of employment. The emergency family medical leave only requires 30 days of employment, just for this reason. It doesn't change the FMLA more generally. Several qualifying reasons exist. We just went over the one qualifying reason for the emergency family medical leave. It is a qualifying reason for the emergency paid sick leave, so it covers both. But the only reason for the emergency family and medical leave, so where you can get up to 12 weeks, depending how much time you've already used, where you can get up to 12 weeks of expanded family and medical leave, is if the employee needs to care for their child whose school or place of care is closed or child care provider is unavailable due to COVID-19 related reasons. So what does that mean? School's closed. When did we see this come up? The end of last year. They were at the end of, I should say, last school year, last academic year. So it started to come up a little bit in May and June when school started to close, April, May, and June. FFCRA came into place on April 1, so people were able to start taking leave. They're not going to get an addition, if they did, they're not going to get an additional 12 weeks now. You apply your standard FMLA look-back period. If they used, hypothetically, 12 weeks of emergency family and medical leave in the end of the last academic year, so say April, May, and June, they're not going to have that time now. So it's exhausted. So their options are much more limited than somebody who didn't use the time last year. So a couple just definition pieces. What is the place of care? Place of care, physical, and these are just the definitions straight out of the Department of Labor regulations. Physical location in which care is provided for your child. A physical location doesn't have to be solely dedicated to such care. It could be daycare, preschool, after-school program, home, summer camp, summer enrichment program, respite care program. Pretty broad, pretty open-ended. Who is my child care provider? Again, these are the things that need to be unavailable for an employee to take the expanded family and medical leave. Child care provider, anyone who cares for your child. Could be a paid person, nanny, au pair, babysitter. Could be individuals who provide child care at no cost and without a license on a regular basis, grandparents, aunt, uncle, neighbor. So a question I get a lot is, well, how am I supposed to know if, who's providing care? It's tough. You don't really know, and there's very little documentation, which I'll get to, I think, on the next slide or two, very little documentation you can actually ask for of an employee. You are somewhat taking their word for it. Now, you do have some tools, depending on how highly compensated your employees are. They're only getting 2/3 of their pay up to a cap of $200 a day for the time spent on the emergency family and medical leave. Plus, if you want to make them get their full salary, you can start to run down their paid time off, their accrued paid time off banks. So you have options. There's strategy in it. You got to really think through it. Again, it's one of those discussions you might want to have with counsel as to the pros and cons of why we would maybe force somebody to use their paid time off, why we would not let them use their paid time off. But those are discussions for another day. So now school reopening. And these are the questions that I said are starting to come in fast and furious. Can more than one guardian take paid sick leave or expanded FMLA simultaneously to care for my child if school is closed due to COVID-19? So 2 family members taking care of the same child, presumably the same worker, because otherwise you're going to have a difficult time saying if somebody works at company A and someone works at company B and there's no relation between the two, figuring out whether somebody at company A is taking leave versus somebody at company B. So you may take paid sick or expanded family and medical leave to care for your child only when you need to and actually are caring for your child. So we're doing a lot of honor system here, which is not always the easiest thing to enforce as an employer. But if you actually are caring for your child and then unable to work or telework as a result of that care, this is all great thinking. If you have a co-parent, co-guardian, somebody else responsible who's providing care, technically you can't take this expanded family and medical leave because you're not the one providing care. I say to that, best of luck proving it. So what can you ask for? What are the documentation requirements? The IRS has set forth, for those of you who have not received the payroll protection monies, loans, and are eligible for FFCRA tax credits, dollar-for-dollar tax credits under this law, you need documentation that satisfies what the IRS wants to get the tax credit. So what does that include? What are you allowed to ask for? And if you need forms or anything of the sort, you can reach out again to counsel. It's something that I know I have, something that I'm sure my colleagues have if needed, but don't hesitate to reach out to me if you need something. You are entitled to get the employee's name, the dates for when they're requesting leave, statement of the reason why they need to leave, which COVID-related or FFCRA-related reason they need it for, a statement that you are unable to work, including telework, because of that reason, and when you have leave based on the expanded FMLA, which is really what we're looking at here, for the school closing or child care provider unavailability, statement from the employee should include the name and age of the child or children to be cared for, the name of the school that has been closed or place of care that is unavailable, and a representation that no one else will be providing care for the child during the period for which the employee is seeking the expanded family and medical leave. And if the child is more than 14 years old and you need to provide care during daylight hours, this is basically the Department of Labor's way of saying a 14-plus-year-old can care for him or herself. To those of you who are mothers and fathers of teenagers, I'm sure you will disagree, but I wish you the best of luck. I don't know how easy I was on my mother when I was over 14, but you live and you learn. Here we are. So if you need to provide care to that child over the age of 14, you need a statement that special circumstances exist that require you to provide care. So the other day, we started to get new FAQs from the Department of Labor. And the other day, I mean yesterday. This first one has been around for about a month. So we'll get through this one, and then we'll go over the new ones, because this is really what parents and employers are going to deal with employees. So Child's school or place of care has moved to online instruction or to another model in which children are expected or required to complete assignments at home. So now, remote learning, distance learning, is it closed? Yes. If the physical location where your child receives instruction or care is now closed, the school or place of care is closed for purposes of the paid sick and expanded family and medical leaves. This is true even if some or all instruction is being provided online, or whether through another format such as, distance learning, your child is still expected or required to complete assignments. So if your child's home, they can't go to school. So let's say a hybrid model where they spend 3 days at home and 2 days in class. So it's 3 days at home for purposes of FSCRA, school is closed. Why do I say that? Because it's been a little bit elaborated upon with these recent FAQs that came out yesterday. So next one. My child's school is operating on an alternate day or other hybrid attendance basis. The school is open each day, but students alternate between days attending school in person and days participating in remote learning. They are permitted to attend school only on their allotted in-person attendance days. May I take paid leave under the FFCRA in these circumstances? Yes, you are eligible to take paid leave under the FFCRA on days when your child is not permitted to attend school in person and must instead engage in remote learning as long as you need the leave to actually care for the child. So you still have to have the child care piece. That doesn't go away, although we often forget about it when we look at the school. For the school reason, for purposes of the FFCRA and its implementing regulations, the school is effectively closed to your child on days that he or she cannot attend in person. You may take paid leave under the FFCRA on each of your child's remote learning days. So the key here is if it's a day where your child cannot go to school for purposes of the FFCRA, that's considered closed and an employee is eligible for benefits. Now, the next scenario that comes up. My child's school is giving me a choice between having my child attend in person or participate in a remote learning program for the fall. I signed up for the remote learning alternative because, for example, I worry that my child might contract COVID-19 and bring it home to the family. Since my child will be at home, may I take paid leave under the FFCRA in these circumstances? I think you're going to see this one a lot. I've seen it a lot. I've counseled on this one a lot. Some parents are scared, and that's fine. It's not. I don't tell anybody how to live their lives or how to raise their families. If a parent is scared to send their child, it doesn't automatically mean that just because of their fear, they get FFCRA leave. It is typical to the same way you have an employee coming back to work when you want them back in the office. If they're scared that they might get COVID, because that's, I guess, a real risk, obviously, that's not enough to just say, okay, I'm never going to come back. I'm going to telework forever. There's a process, there's dialogue that needs to occur. In the school, in the education realm, we have when the parent has a choice, they can send their child to school. They choose not to, but they can. School is open. What happens? You are not eligible to take paid leave under the FFCRA because your child's school is not closed due to COVID-19 related reasons. It is open for your child to attend. It sounds self-explanatory, but a lot of employees are trying to play this to their advantage. FFCRA leave is not available to take care of a child whose school is open for in-person attendance. If your child is home, not because his or her school is closed, but because you have chosen for the child to remain home, you are not entitled to FFCRA paid leave. However, if because of COVID-19 your child is under a quarantine order or has been advised by a healthcare provider to self-isolate or self-quarantine, you may be eligible to take paid leave to care for him or her. And that's only the emergency paid sick leave. That is not the emergency family and medical leave. Because remember, the emergency family and medical leave is only for the school closure reason. The emergency paid sick leave, which is the 80 hours for a full-timer, prorated for a part-timer, that covers more. That covers caring for an individual subject to a quarantine order or told to self-quarantine by a doctor. That covers both of those. Last example. My child's school is beginning the school year under a remote learning program out of concern for COVID-19, but has announced it will continue to evaluate local circumstances and make a decision about reopening for in-person attendance later in the school year. May I take paid leave under the FFCRA in these circumstances? Yes, you're eligible to take paid leave under FFCRA while your child's school remains closed. So I think we all know this. Just wanted to give you all the recently added FAQs. If your child's school reopens, the availability of paid leave under the FFCRA will depend on the particulars of school operations. Is it remote? Is it hybrid? Is it completely in person? Who knows? Does New York quarantine leave law apply? So the emergency COVID paid sick leave law from the state, the one that you get if you're subject to a quarantine order or your minor child is subject to a quarantine order or a mandatory precautionary quarantine order issued by the state or the Department of Health. So there's an older now FAQ from the New York State website. Child school is closed due to COVID-19. Can I take the PFL or disability benefits? Remember, you only get the emergency COVID paid leave when your child or you is subject to a quarantine. You do not, the school closure is for social distancing precautions. It was not for schools closing, was not a quarantine order from the state. So can you get any of these expanded benefits if you're a smaller employer? Can you get the paid sick leave, the COVID paid sick leave, the state law, not the federal law? This applies to all employers, whether you have 1,500 employees, doesn't matter. This applies to everybody. No, you can't get it for the school closure. Schools remain closed for the rest of the academic year. This, again, was last year, but it's going to carry over the same concept last academic year. So the concept will carry over. This is not a qualifying reason for PFL/disability benefits, as these benefits are only available when you or your minor dependent child is subject to a mandatory precautionary order of quarantine. How did that, I went the wrong way. Hold on. Okay. So takeaways. What should an employer be doing or thinking about? Most importantly, preparing for potential staffing shortages, hybrid work arrangements, and remaining open to telework. I understand it's something that a lot of employers shied away from prior to February of 2020. It's unfortunately, I guess unfortunately, because it's taken this virus for that to happen, but it has become telework has become more of the norm, more of a regular issue employers have to deal with. While you have employees teleworking, don't lose sight of the goal. Make sure you keep an eye on productivity and performance metrics. Don't just assume because people are working at home that they're all working the same. You still have a job to do to make sure that your managers are managing the employees and making sure that everybody is following company policies, harassment policies, anti-discrimination policies, overtime policies. Everything still applies. It doesn't end just because somebody is working remotely. Treat them as you would in the office. The SHRMLI ends at the end of this year, December 31st, 2020, 11:59. We'll be ringing in a new year and we'll be ringing out SHRMLI, provided it is not extended in any kind of federal legislation. It hasn't happened yet, but we have 4 long months, and the way that the government moves, we might find out by 2023 if they extend it. So right now, this is something that you're probably only going to have to deal with for the first semester or so of the academic year. It doesn't look like something that's going to come up in the spring. Last thing I will add, fortunately I can't spend too much time on it, but there was a recent Southern District of New York decision that kind of curtailed some of the FFCRA Department of Labor regulations, primarily the things that are pulled back on. If you have questions about this, again, please reach out to your counsel or reach out to me if you work with me, Jackson Lewis, one of my colleagues, whoever it is. What changed as far as the Southern District's decision? The definition or who qualifies for the healthcare provider exemption, what happens to employees on furlough, whether they can collect benefits under FMCRA, whether they're eligible or not. The DOL says you can't. The Southern District decision seems to intimate that you can if you're on furlough. And again, whether this applies to you, it's kind of an open question, but it's something worth talking through with your counsel. More importantly, the requirement that employees secure consent for intermittent leave for certain qualifying reasons. So the DOL said that you cannot take the extended family medical leave intermittently unless your employer approved it. This Southern District decision kind of walks that back and seems to say that an employee can request intermittent leave and have to have it granted, even if the employer doesn't want to grant it, which makes some practical sense, but could be a nightmare staffing-wise for employers. And the requirement that documentation be provided before taking leave. We went over the documentation requirements before, and the DOL said that those things had to be given to the employer prior to the start of leave of absence. The Southern District decision seems to walk that back as well, and it could be given to somebody provided by the employee after the leave already had started. So the Southern District decision did nothing to help employers, made things a little bit more confusing and difficult, but that's nothing new. With that said, I apologize for running over. I thank everybody for tuning in today. Have a wonderful weekend. Have a wonderful safe Labor Day holiday. I know we're a little longer. We got a week plus until then. Hopefully some people are able to get some time away with their families. Enjoy. Have a wonderful weekend, a wonderful September. I will talk to you at the end of September, and then who knows, sooner rather than later, hopefully we will all see you back at the Melville Marriott for the breakfast series. So take care, everybody. Have a great day. Bye-bye.